Hey everybody, I am Benjy Smith from Smith Law. This is the DialBenjy podcast, episode number 4. Smith Law is a law firm that represents employees all throughout California and New York in discrimination, harassment, and retaliation cases. Today we're going to talk about pregnancy leave, pregnancy discrimination. When I tell people that I have cases for women, people are really surprised. They can't believe that bigger companies or any company would engage. It is rampant in the workplace. You would not believe the companies that are engaging in these practices in 2024. Obviously, there's nothing more sickening than somebody discriminating against a pregnant person or a person that is expecting a newborn, or in the aftermath of the child being born, discriminating against the parents for needing to tend to their children. There are better laws in other countries like in Europe and all over the place as it relates to this, but California, New York, and other states are trying to catch up. But what we have is, just in the past month, I have been retained on a few cases against very large companies where employees literally performing incredibly well. They were at the top of their game. I have one client who we're just about to file a lawsuit for against a major company that we all know, that she was working in all of her KPIs, which are short for key performance indicators. She was at the top of her entire department. And just the week before her termination, she scored in key performance indicators in one very important subject. She did better than almost the entire rest of her team combined. Yet a week later, she was terminated. But what happened in between the time that she was doing really well and the time that she was terminated, other than her great performance? Well, she revealed that she was pregnant. And in response to that, the company is going to claim that either they were going through a hard business time. That's not going to work here. They may claim that my client was not being as productive as they would like. That's going to be hard to show because she had really great performance just the week before her termination. And she never had any write-ups or anything like that. So for anybody that doesn't believe that pregnancy discrimination is still rampant in the workplace, they're wrong. So if you're watching this video and you have the inclination that you are being discriminated against or harassed or retaliated against or anything in connection with your pregnancy or your newborn, you have the right idea. You are entitled to protections in the workplace. So let's just start off with, generally, what are your rights as it relates to taking pregnancy discrimination leave? So in California, there's several protections, and there are protections at the federal level as well. And so we're just going to talk today about the California protections that you have as it relates to your newborns. So there is the California New Parent Leave Act, and that allows eligible employees to take up to 12 weeks of leave within a year after their child is born, adopted, or placed in childcare. The time off is for bonding with the new child and can be taken by parents for work for private employers with at least 20 employees. And that's super frustrating sometimes. Sometimes there are laws that only apply to companies that have a certain amount of employees. We have that all the time. We have people that come to us and they have certain claims that only apply to you if certain employees. And you're like, why should my rights depend on the amount of employees? That's just unfortunately the way it is sometimes. But we can't really tell you if your situation is qualified to meet a certain threshold until we talk to you, because sometimes we're able to, sure, you can't meet the threshold for a certain law's protections, but we're able to find protections under a different law's protections. So when you hear people talk about needing to have a certain amount of employees to meet a certain threshold, it may be true as it relates to a certain protection, but there may be another way to get you that very same protection under a different statute. Just wanted to make that side note. So during this leave that you're able to take, you can also use different accrued vacation time, sick leave, or you can negotiate with your employer, work with your employer to increase the time off that you're able to take if they're willing to do so. And then when you're returning for your leave, you have the right to be reinstated in the same or comparable position. So if you come back and they're like, okay, you had a job where you were supervising 4 other employees, and then you come back and they're like, okay, yeah, you still have the same pay, but now you're not supervising any employees and we're going to start giving you different types of tasks, that might be pregnancy discrimination. We'll have to talk about it. There's obviously, it's very fact specific. So it's important for both employers and employees to understand these rights and obligations to ensure a smooth transition. So the next thing I want to talk to you about is just the Pregnancy Discrimination Act. So you got fired after returning from your pregnancy. The next question I get often is, I got fired after informing my employer that I was pregnant. You likely have a case. You likely at least have a case that warrants looking into, but we have to look at the facts of the case. If you, for instance, parents are pregnant, but you're engaging in really horrible conduct as an employee, you may not have a great case. If you are pregnant, but they are laying off 1,000 people or shutting down the business, you may not have a case, right? Because the employer might be able to claim that your firing has absolutely nothing to shutting down the company, and it's not likely going to be pregnancy discrimination. But if you were fired after informing your employer that you are pregnant, you might have a case. But the Pregnancy Discrimination Act protects you from discrimination based off pregnancy, childbirth. This means they can't fire you, demote you, reduce your hours, change your job responsibilities, or take any adverse action against you because of your pregnancy. Now, they're making the argument because of this or that. That's where we have to really look under the hood and examine your situation on a case by case. So if you've been fired after you've let your employer know that you are pregnant or anything related to, whether it's now you feel like you're being discriminated against because sure, the employer was okay with you being pregnant, but now because you have to go for increased amount of medical appointments, you feel like they're taking it out on you, should be examined by an employment lawyer in your state. Another question we get is, what is the maximum duration of leave allowed during our pregnancy? And that question is somewhat complicated because it's a gray area. After the protected leave, if you need an extension, your job is not required to keep the position open for you. Your job is not required to keep your position open indefinitely. That is for pregnancy or any disability. It is a very case-by-case situation. So after you've taken your pregnancy leave, and let's say you're supposed to come back on January 1st, if you have a doctor's note at the end of December that says you need to extend your pregnancy leave or your pregnancy-related leave for another 2 weeks, the employer is required to engage in a good faith interactive process with you where they work with you. If you've been working for the company for, let's say, 5 years, and you need an extra 2 weeks to come back from your pregnancy leave, that is a case that I'd feel comfortable taking because it would be very hard for an employer to explain that they can't wait an additional 2 weeks for you to come back. But every case is different. Not every case is the same. So when I say that, I really have to look at your specific case to understand. But the bottom line is there are great protections for pregnancy in the workplace. You just have to be able to have the time and patience to talk to attorneys about it throughout the process. And you could talk to attorneys about this even when there's not a problem, just so you understand your workplace rights. The duration of leave is made on a case-by-case basis, taking into account factors such as your medical condition, the employer's policies, and any undue hardship on the employer. When people say undue hardship, people don't quite understand that. When they say undue hardship, they are referring to a company may at times under certain statutes make the argument that it is just unreasonable to provide an extended leave to people who are pregnant or people who have any sort of medical conditions. And what they're going to say is that your position is really critical to running their business and they cannot be without you. And they can't just hire somebody temporarily, especially if you're continuing to ask for like multiple extensions of your leave. It's just too hard on a business. That's the argument that they're going to make. So whenever you hear that term undue hardship, that's what they're referring to. The next question is, my employer told me verbally that I get to take more time than what the law actually provides me. So let's say, for instance, the law provides you 12 weeks, but your employer was like, hey, I'm going to give you an additional 4 weeks of leave. So you're going to have 16 weeks, but you didn't have it in writing. When I returned back on the extended date, the additional 4 weeks, I got fired. Do you have a case? Sometimes. Employers agree to give their employees more time off sometimes for medical or family reasons. It happens more than that's required by law. Even though the extended leave was done verbally, the courts have recognized verbal agreements and promises made by employers are as legally binding under state laws as ones in writing. If you can provide evidence or documentation of the agreement, such as emails, witnesses, or any sort of other written communication, it could definitely help to any legal question. So oftentimes when you hear me provide content and I say you're going to have to consult with an attorney, maybe you're thinking that that's just a way for an attorney to get more business or to get more calls. It's really not. It's really about the fact that unfortunately no two situations are exactly alike and laws are complicated, and that's why there are lawyers to work through these issues. But if you have any sort of pregnancy related questions, concerns that are happening or you're concerned about happening, feel free to contact us at thesmithlawcorp.com, or you could find us at www.smithlaborlaw.com, or you can call us at 1-833-SMITH-LEGAL. Thank you so much. And also, if you can, comment, give us any feedback you can on these episodes, on our social media. We have TikTok, we have Instagram, we have our emails. We love to hear from you. Give us feedback on anything that you want to hear about, anything that you've heard us talk about. We appreciate you listening. Thank you so much. My name is Benjy Smith from Smith Law. We'll talk to you soon.